Okay, so we are going to be discussing sales contract negotiation, performance, and termination. And I don't think these are specific to Maryland. I think it's anywhere. Some of them might be specific. All right. So every state might have their own negotiation rules. So you'll just need to check. But this will still help you. This video will still help you. Because a lot of these overlap one another. I have real estate license in 2 states, and a lot of them are the same in each state. I'm not going to read all this story because this is crazy. Contract Negotiation 101. This is kind of good. Offer presentation, counteroffers, disclosures. During the negotiation process of the buyer's agent to negotiate on the buyer's behalf and ensure the buyer gets the property at a fair price. Without a signed agency agreement, the licensee cannot legally advise the client. A seller cannot counter a buyer's initial offer, but a buyer cannot counter the seller's counteroffer. I don't think that's true. One of the agent's duties is the duty of confidentiality, and an agent can harm a client negotiation position by mishandling confidentiality information. Mishandling confidential information is a serious violation. A counteroffer is a cancellation of the prior offer. Which of the 4 best practices does Kiara use when preparing her client's counteroffer to the seller? Okay, all these things right here. More on presentation, facts, and questions. All right, rescinding an offer. What if the seller receives a better offer than they had already given the Kellermans the offer? But before the Kellermans a recounter, can the sellers back out of the deal? I don't think so. Okay, there's no signed contract, so they can back out of the deal. Okay. Negotiating the sales contract between the parties. Again, you cannot mishandle confidential information. It could harm your clients, and they could lose whatever it is they're trying to get. All right, what is partial performance and what is performance? Performance of contract. And I'm not reading all of this. All right, performance of contract is when some of the terms are met by the buyer and seller. Performance of contract is when both the buyer and seller meet all the terms. One or both parties have completed only a portion. It's probably a partial performance. One party did not meet a specified time frame, which is specific performance. And due to circumstances out of their control, they cannot legally or practically do what they agreed to do. All right, in performance of a contract situation, after parties fully perform the contract and the contract has been executed, the parties are discharged from their duties. All right, in a performance of a contract situation, after they both fully perform the duties and the contract has been executed, the parties are discharged from their duties. I'm guessing. Partial performance always results in termination of the contract. Impossibility of performance occurs when the property is destroyed or made subject, maybe. Specific performance can be satisfied through property or monetary damage. It is impossibility of performance situations the party is released. Only meeting the terms of the original contract qualifies for a specific performance. Okay, let's see what we got wrong here. Specific performance requirements can be satisfied through property or monetary damages. No, that is not true. Okay, so let's go and look at this. All right, let's do this again. True, false, true. This is false. I already determined that. Whoops, this one's true and this one's true. Okay, only meeting the terms of the original contract qualifies for specific performance. If you're taking any screenshots, you can do that now. Okay. Performance of a contract. Both parties have fully met the terms of the contract. Partial performance is one or both parties have completed only a portion of the terms agreed in the contract. Specific performance is one party did not meet the terms of the contract and is now being required to do exactly what was agreed. Impossibility of performance is due to circumstances out of their control, and they cannot legally or practically do what they agree to do. All right, handling of earnest deposits in Maryland. Okay, this could change. The rules could change in your state, so you'll need to check your state. A lot of them are overlap. They're pretty much the same. The broker has to handle it and put it in an interest-bearing account. All right, this is true. They want to provide. You want to do this because it gives the seller confidence. The amount of interest money is negotiable but is considered reasonable. The seller does not have the right to make a counteroffer on the amount of interest money put down. The earnest money represents compensation a seller might claim should the buyer in some way default. Okay, all of these are true except for this one. The seller does have a right to counteroffer if they don't like the terms. Okay. Okay, the amount of interest money is negotiable between the parties. Earnest money is a huge area for lawsuits against real estate licensees and their broker. Could be. Earnest money is held by the seller. No. Earnest money must be placed in an escrow account within 7 days. I believe it has to be more than that. Regardless of the circumstance, earnest money is always returned to the buyer if the agreement is terminated. No. The escrow agent is responsible for maintaining the escrow agent. I don't know what an escrow agent is. Okay, I guess that's the same as a broker. Earnest money must be placed in an escrow account within 7 days. Okay, I thought it was before 7 days. That's why I put false. Okay, so that one's true, and then the bottom one is true. All right, so I know this is true, so I'm going to put that true. Earnest money is held by the seller. No. Must be placed within an escrow account regardless. Earnest money is returned to the buyer. No. Okay, you got it. Earnest money is held and maintained by the escrow agent, which I thought was the same as the broker, which I do believe. If earnest money is deposited and clients are unable to reach the terms, it is dispersed according to the terms of the agreement between the parties. It is illegal for licensees to engage in the following activities regarding escrow. 2. I don't know what the other one is. I'm guess capping. Commingling and conversion. Correct. Okay. Commingling is a legal use of the money, and I don't know what conversion is. I guess it's put in their own bank account. Placing an earnest money deposit in an escrow account within 7 days is not a violation. Misgrowing personal funds with escrow funds is a violation. Failure to keep accurate accounts is a violation. Dispersing to the seller after the buyer has defaulted is a violation unless you've got a lot of things going on here. Failure to maintain escrow records for a period of 5 years is a violation. And using funds to pay for business cards and advertising. Okay, so we got all of these right. Pretty much everything is a... We do not disperse the funds to the seller unless you go through a whole... you have to go through a lot of legal stuff first before you can give money back. And the seller usually is not going to get the money. And normally it's going to go to the buyer unless they go to court and fight it out. All right, handling earnest money. I know our state has strict regulations governing what a licensee can do. So you need to find out what the rules are for you. But most of the time, it is going to be in an interest-bearing account, and it's going to be held by the broker. That's Basic Rules 101 for all states in the United States. All right, contract breaches and the remedies. All right, what happens if you breach a contract? All right, both parties do to meet the obligations by not providing signed contracts. That's not right. It was not caused by the sellers. Okay. They failed to deliver the earnest money. We're still on earnest money here. All right. Review each of these remedies and decide if the remedy can be used to address a breach of contract. All right. Decide to unilaterally rescind the contract. Sue for a specific performance. Demand the guilty party pay half the asking price. Accept liquidated damages. Require the guilty party find someone else to fulfill the contract. Accept partial performance. I don't think this one is, but we're going to put yes. Okay, so the only two that are not yes are demand the guilty party pay half your asking price. That's not a remedy. And you cannot require that someone else fulfill the terms of the contract. Okay. This one is no. And this one is no. All right. You cannot sue. Yes, you any of these things breach a contract. All right, build a story. Oh God. All right. Should Sam allowing the breach but requiring that the contract move forward? Boy, oh boy, oh boy. All right, if he's going to sue, why not blank and force the buyer to fulfill the buyer to why not sue for a specific performance, sue for monetary damages. He's going to take the guy to court and at least get something for his lost time and aggravation. The buyer has put down a hefty sum, and Sam could always decide to rescind the contract or protects, take the hard line, and without giving guilty party any say and unilaterally accept liquidating charges. And perhaps it would be better to talk it over with the buyer and have them mutually rescind the contract. Sam should accept partial performance, allowing the breach but requiring the contract to move forward. Or perhaps he should take the hard line and rescind the contract unilaterally without giving the party any say. Or it would be better to talk it over and have them mutually rescind the contract. Then again, why let the party off scot-free? Could always decide to accept liquidated Damages, sue for performance. Okay, so we almost got all these right. That's not bad, considering there were so many questions in here. Okay. All right, so let's do this again. All right. Set partial performance. Rescind the contract unilaterally. Mutually rescind. And Sam should always decide to liquidated charges. And this could be monetary. And this could be specific. Okay. All right. Suing for monetary damages is a remedy sought by buyers who have discovered a defect in the property after closing on the deal. I don't know about that. Okay, because buyers are really the wrong in the real estate deal, sellers are the one who will decide to employ a unilateral decision. Accepting partial performance is a remedy that either the buyer or seller could employ. Accepting liquidated damages is the seller's only remedy for a contract for purchase. Suing for specific performance is a remedy sought by buyers. I want to say no. In order for mutual rescission to be used, both the buyer and seller must agree to terminate the contract. Okay, so these two are true. Okay, let's look at this for a second. Suing for a specific performance is a remedy sought by buyers. Sellers rarely pursue this. All right, so that's for sellers. Specific performance. Liquidated damages is often the seller's remedy. So buyers do specific performance and sellers do liquidated damages. Okay. Okie dokie. Let's see what we got here. Okay, this one is false. This one is false. And this one is true. And I believe this one is true. Okay. Breaches of contract can be caused by either party. A contract may be also discharged or terminated through operational law, which is an example of this. No. Okay. Title search. Reveal the seller didn't have the legal right to sell the property. Okay, that's a different one. All right, contract breaches and their remedies. A wronged party can take any of the following options to remedy a breach of contract. You can sue for damages, specific performance, liquidated damages, rescind the contract, accept partial performance, or rescind the contract unilaterally. All right, record keeping. I went over this so many times on so many videos, and I keep bringing the same stuff up over and over again. But, you know, repetition is the way to remember, right? All right. Okay, that's how you remember. You just keep repeating it. So that's why you need to keep doing these videos. Erasing and editing capabilities disabled. This is electronic record keeping systems. I believe so. Stored in regular course, licensee's busy, identification, indexing, alphabetical storage. One of these is not required. Alphabetical storage, okay. This is required. Regular course, identification, indexing, but alphabetized storage is not required. All right, thank God that's a little thing because we're running out of time. All right, so good. All right, the unit exam is 4. 4 questions. So we can only miss 1 to pass. All right, and which of the following scenarios is impossibility of contract performance occurring? Beyond their control, the parties cannot legally do. All right, which of the following is not required to present to a client? A written offer that was emailed. Details of an, well, they can't do this one. Details of an oral offer. I think because it's not in writing. Okay. Can the buyer back out on this situation? Buyer client made an offer on Tom Seller's client home, which the seller countered. Client offer sent another counter back on Tuesday. Called to say the seller was accepting their offer, and he sent over the signed paperwork on Thursday. He told him the good news, but he told her he'd rather back out of the contract entirely. Can the buyer back out? I believe so. Which of the following statements about the counteroffers is true? I'm thinking this one. Once a counteroffer has been made, the prior offer is canceled. Okay, we got one wrong. Let's see what we got wrong. Okay. No, a counteroffer is considered accepted when the offer is signed and the offeree is notified. So the buyer cannot back out. Once the counteroffer is considered accepted and the offer is signed, they cannot back out. Okay? The contract is not, well, it's kind of signed. Yeah, it's really signed, so I guess that makes sense. All right, I'm going to go kind of slow here, and if you're continuing along, we will be on trust and escrow accounts next, but I'm going to go slow in case you want to take a picture of any of these questions to use in your studies. And I'm so glad we're getting out of contracts because we had like 5 or 6 videos, maybe more, on just contracts. So I've had enough of contracts for a while. Okay, this is the one we got wrong. Remember, in green is correct. Alrighty, so that's going to end this video. I'll see you all in the next one.